Welcome to the Deep Dive. Today, we're getting into something really fundamental, a huge question about how America is governed right now. Is administrative law itself, the whole system covering agencies like the EPA, FCC, FDA, all of them, is it actually compatible with the U.S. Constitution?
It's a massive question, and it's really more of an indictment than just a critique. It challenges the basic legitimacy of how the federal government has worked for, well, the better part of a century now. We're diving into Philip Hamburger's work. His really substantial book is Administrative Law Unlawful, and his argument, it's pretty radical, sweeping, you could say.
Yeah, because most debates about these agencies, they focus on the policies, right? Like, should the EPA regulate this way, or is the FDA too slow with that drug? But Hamburger seems to be saying, look, that's not even the main point.
Exactly. He makes that crystal clear. His problem isn't what the government is doing, Social Security, environmental rules, that kind of thing. He's focused completely on how it's doing it, the method, how it drives, as he puts it. His basic claim is that when the executive branch makes the rules and judges people for breaking them, bypassing Congress and the courts, well, that's just off the constitutional map.
So unlawful then, and dangerous in his view. Okay, so our job here is to really unpack why he sees this administrative power not just as, red tape or a necessary evil for a complex world, but as something much older, much more threatening, a return to what he calls absolute prerogative. That term itself, prerogative, feels heavy with history. What's the link he's making?
Right. Absolute prerogative, historically referred to that power English kings claimed, the power to make binding rules completely outside of Parliament, outside the ordinary law, extralegal power. Hamburger argues that what administrative agencies do today is structurally the same thing. See, under the Constitution, he argues, the government can only legally bind you in two ways: through laws passed by Congress, your representatives, or through judgments from independent courts, Article 3 courts. Administrative power, it sidesteps both. That makes its commands sort of absolute. They're decrees, not laws made with consent or judgments based on law.
Okay, so we need to start with that history, this idea that government power has to flow through law, not just decree. Where did that come from in the Anglo-American world? Because it sounds like the absolute foundation for the American system.
Oh, it absolutely is. And it wasn't easy. It was a long, hard fight over centuries. You can trace it from Magna Carta way back in the 1200s, where the king basically agreed, okay, I'll govern by the law of the land, all the way through the English Civil War, the Glorious Revolution in the late 1600s. The whole point, the ideal that emerged, was governance through law and under the law, what we typically just call the rule of law.
Rule of law meaning the king couldn't just decide things on his own. He needed Parliament. Needed the courts.
Precisely. The goal was always to make sure the government acted through laws passed by the legislature, Parliament, representing the people, and through judgments made by independent courts. It was all about dismantling that royal claim to absolute prerogative, that power kings wielded outside the normal legal system, extralegal, and sometimes even above it, supralegal.
So it's deeper than just separating powers like legislative, executive, judicial. It's about rejecting any binding government action that doesn't come through those specific accountable channels.
That's the core insight, yeah. And Hamburger actually breaks down this old absolute power into three key features. Features, he argues, we see mirrored, worryingly, in today's administrative state.
Okay, let's get those three elements on the table.
First, there's extralegal constraint. This is power that operates alongside the normal legal system, or just completely outside it. It might look like law, they issue rules, hold hearings, but it's really dodging the constitutional institutions, the proper procedures, and crucially, rights like due process. It's like a shadow government, almost.
Looks legit, but it avoids the safeguards. Okay, what's number two?
Number two is rising above the law, the claim to be superlegal. Historically, kings claimed their prerogative wasn't really subject to judicial review. James the Herb famously told judges it was no subject for the tongue of a lawyer. Today, administrative power gets something very similar through judicial deference doctrines. Courts are often told to defer to the agency's interpretation of the law, essentially letting the agency's view trump even what a judge might think the law actually means. It puts the agency's view above the court's independent reading of the law.
And the third element takes us back to government structure.
It does. The third is consolidation of power. Absolute rulers hated having their power divided. The American Constitution, by contrast, deliberately specialized power. Lawmaking will belongs only to Congress in Article 1. Independent judgment about law belongs only to the courts in Article 3. Executive power, the power to enforce, is separate again. This specialization protects liberty. Absolute power, however, and Hamburger says administrative agencies too, merges these powers back together.
Wow. So the Constitution wasn't just dividing tasks for efficiency. It was actively trying to prevent this very consolidation, this historical pattern of tyranny.
Exactly. It was a deliberate anti-prerogative design. All those checks and balances, 2 houses of Congress, the president's veto, lifetime judges, they were all aimed at stopping legislative, judicial, and executive power from ending up in the same hands. And Hamburger's point is that your typical regulatory agency is functionally all 3 branches rolled into one, sitting under the executive.
Okay, let's dig into the first big area then, lawmaking. How does he make the case that when an agency makes a rule, it's not really law, but something else, extra legal command?
Well, he argues that when, say, the EPA sets a specific emissions limit or the FDA dictates exactly how a food label must look, these legislative rules act like laws. They bind the public. But they aren't Article I laws. They're commands. Why? Because they lack that essential ingredient, the consent of the people given through their elected representatives in Congress passed as an actual statute.
This sounds exactly like those old fights over royal proclamations you mentioned. That parallel seems really key to his whole book.
It's absolutely central. He constantly draws that historical line. You know, back in the 1600s, kings like Henry VIII and James Akar tried to use proclamations to make rules without Parliament. And it blew up in 1610 with the case of Proclamation.
Right. Tell us about that one.
That's when Chief Justice Edward Coke stood up to James I. The king basically argued, look, if the law is silent on something, I should be able to issue a binding proclamation, especially if it's urgent or necessary. Coke flatly rejected that. He established the principle. The king cannot change the law or create new offenses by proclamation alone. If you want a new rule that binds people, you need Parliament. Period. Necessity doesn't override that.
And today, the arguments for agencies making rules often sound, well, pretty similar, don't they? Efficiency, complexity, needing quick action. It sounds a lot like James I.
It's precisely the same justification, Hamburger argues, just updated for a more technical age. He thinks the modern executive branch kind of assumes the constitutional problem was just the word proclamation, not the act of making binding rules outside the legislature. So now they call them rules or regulations, but the core issue imposing obligations without legislative consent is identical.
Is there another historical example of this kind of extra legal power grab the founders would have been really concerned about?
Oh, definitely. Taxation without representation, prerogative taxation, that was huge. It was bedrock constitutional understanding that taxes required Parliament's approval because, as one legal thinker, Whitelock, put it, the power of imposing and power of making laws are convertibilia and coincidentia. Basically, taxing is lawmaking. So Hamburger argues, when an agency today issues a rule that forces companies or individuals to spend huge amounts of money or pay hefty fines, that's effectively a form of extra legal taxation. It's bringing back something the Constitution was meant to absolutely forbid.
And what about when the executive doesn't enforce a law or excuses someone from it? Waivers, dispensations. That sounds like prerogative too.
Yes, the dispensing power. The power to just relieve someone from having to follow an existing law without actually changing the law itself. This was incredibly controversial. James II used it extensively, often seen as playing favorites, and it was a major reason he got kicked out in the Glorious Revolution.
And Hamburger calls modern administrative waivers doubly lawless. Why doubly?
Because first, the agency itself is acting outside the law when it grants the waiver. It's not usually following some clear statutory instruction on who gets a waiver and why. Second, it then allows the person getting the waiver to act above the law that everyone else has to follow. It's pure executive discretion, an act of favor, not law. And the danger, he stresses, is favoritism. Waivers don't just go to anyone. They tend to go to those with the resources, the connections, the lobbyists, those who have close contact with the administration. It undermines the whole idea that the law applies equally to everyone.
Okay, but the standard defense you always hear is delegation. Congress chose to give this power to the agencies. They delegated it. Why does Hamburger push back so hard on that, insisting it's sub-delegation? That sounds technical but important.
It's absolutely crucial to his legal argument. He says, wait a minute, where did Congress get its power in the first place? From the people. We the people delegated legislative power to Congress in Article 1. Congress is our agent. Now think about basic agency law, or even just common sense. John Locke argued this foundational point. If you delegate a power to someone, they usually can't just turn around and give that power away to someone else.
Right. If I hire you to manage my finances, you can't just hand over my checkbook to your cousin without my permission.
Exactly. That's the analogy. Congress is the agent. The executive agency is the cousin. Hamburger argues the Constitution itself forbids this. Article I says all legislative powers herein granted shall be vested in a Congress. He reads that all, and that specific vesting as an explicit bar on Congress transferring its core lawmaking power somewhere else. The problem today, he says, is that courts and scholars often just assume delegation is fine, or that the non-delegation doctrine is basically dead. But he argues they're missing the fundamental point. The power to bind the public was given exclusively to Congress because only Congress provides democratic consent. It can't be handed off.
Okay, that sets up the transition nicely. If agencies making rules is extra-legal legislation, what about when they hold hearings and issue penalties? What's administrative adjudication?
That, he argues, is extra-legal adjudication. It's not Article 3 judgment, it's what he calls control. Agencies make incredibly important binding decisions about individuals and companies. They demand information, they investigate, they effectively prosecute, and then they decide guilt and impose penalties, fines, cease and desist orders, things with real consequences. And to do this, they need their own tribunals operating completely outside the safeguards of Article 3 courts.
And this gets back to that third element you mentioned earlier, consolidation. The agency is investigator, prosecutor, and judge all rolled into one.
Yes, and that consolidation is the core structural problem here. It mirrors those infamous historical prerogative courts like the Star Chamber or the High Commission in England. Those courts were essential tools for enforcing the king's will, especially for rules made outside Parliament. They dealt with what were called crimina extraordinaria offenses that weren't clearly defined in existing law, kind of like violations of modern regulations often are.
What was it about those courts, like the Star Chamber, that made people fear and hate them so much? What abuses really drove the American founders to insist on things like due process?
Well, a huge part was their complete evasion of due process, especially the right to a jury trial. They didn't have independent judges. The judges were basically political officials. And crucially, there were no juries. No grand jury to indict, no paid jury to decide guilt. They often used inquisitorial methods, leaning heavily on accused people to incriminate themselves, sometimes under duress. Americans remembered this history vividly. Think about the fights over the Stamp Act. A big reason they hated the Admiralty courts enforcing it was because those courts operated without juries. Hamburger argues the administrative state brings back this juryless adjudication, even for cases that feel very much like criminal prosecutions, just with civil penalties.
Let's focus on the judges themselves for a moment. The difference between an Article 3 federal judge and an administrative law judge, an ALJ. What's the key structural distinction for Hamburger?
It's absolutely fundamental. An Article 3 judge is supposed to exercise independent judgment based on the law of the land. That's why the Constitution gives them protections, lifetime tenure during good behavior, and salary protection. These weren't just perks. They were hard-won safeguards against political pressure. Remember James the Serf firing Chief Justice Coke for defying him? Those protections are meant to ensure a judge's loyalty is to the Constitution and the law, not to the president or Congress who appointed them.
And ALJs, how are they different in practice?
They don't have those constitutional protections. They're employees of the agency. They hold administrative positions. They're generally expected to exercise policy judgment aligned with the agency's goals, not purely independent legal judgment. They have to follow the agency's regulations and interpretations. Hamburger argues they're essentially committed to the overall project of administrative power, unquote. They report up within the agency. Their performance can be reviewed. They can potentially be reassigned or even removed in ways an Article 3 judge cannot. It's a completely different role. One is about neutral legal judgment. The other is ultimately about implementing agency policy.
So simplifying it, maybe an ALJ in an EPA hearing is thinking, does this action fit our regulatory goals? While an Article 3 judge has to ask, did this person violate a specific law passed by Congress according to the rules of evidence and procedure?
That captures the functional difference really well, yes. The ALJ is, in a sense, part of the enforcement team. The Article 3 judge is meant to be the impartial referee, focused only on the law.
And this structure, he argues, also brings back those old inquisitorial methods that due process was supposed to eliminate.
It does in certain ways. Due process, as it developed in the common law, was a rejection of the inquisitorial system. But look at how agencies often operate. Those old prerogative courts were notorious for pressuring self-incrimination. Today, agencies frequently issue broad demands for information subpoenas, reporting requirements based just on their authority, ex officio, not on any specific charge of wrongdoing. They're essentially fishing for violations, compelling businesses and individuals to hand over documents that might end up incriminating them, often before any formal case is brought.
What about searches and seizures? The Fourth Amendment concerned about warrants.
Right, that connects back to the colonists' fight against things like general warrants and writs of assistance, which James Otis famously argued against. Historically, the power to issue a warrant to search someone's property was a strictly judicial function, requiring probable cause shown under oath. Hamburger argues that administrative warrants, often called inspection warrants or administrative subpoenas for records, usurped this judicial role.
Allowing agencies to conduct searches without meeting the same standard.
Essentially, yes. They allow searches based on the need to ensure compliance with regulations rather than probable cause of a specific crime. It feels very much like those old general warrants that gave officials broad authority to search private papers and places, delegating judicial power to executive agents for fishing expeditions, as Otis called them.
Okay, so we've got this picture. Administrative power merges functions, uses command instead of law, control instead of judgment. Let's talk about the stakes. Why should someone listening care about the difference between an ALJ hearing and an Article 3 court trial? What's the impact on liberty?
Well, the stakes are really about the nature of our freedom and self-government. When you consolidate power this way, Hamburger argues, you create this nearly freestanding coercive power within the executive branch. The agency writes the rules, enforces them, judges violations. Its power is only vaguely limited by the original statute Congress might have passed decades ago. And the result, fundamentally, is the risk of arbitrariness. You replace the cumbersome, slow, but rights-protecting constitutional process with something faster, more efficient, but much more prone to unchecked power.
And it changes who gets to make the rules that bind us. You mentioned his critique of the knowledge class.
Yes, that's a huge part of the liberty concern. Administrative lawmaking is, by its nature, unrepresentative. These administrators aren't elected, except ultimately the president, who is just one person. So the power to make binding rules gets shifted away from Congress, your elected representatives, to what he calls the knowledge class.
Who are they exactly?
The experts, the specialists, the technocrats within the agencies, people who believe, often quite sincerely, that their specialized knowledge gives them the authority and maybe even the duty to make decisions for society, especially on complex issues. They tend to value expertise over messy democratic consent.
So the trade-off is popular consent, which is kind of the bedrock of the Constitution, for efficiency and expert knowledge. But what's the inherent danger there if they're just trying to solve problems effectively?
The danger is that this class becomes entrenched, making rules from within the government, but without direct accountability to the people. The issue commands as if they were members of a ruling class, Hamburger writes. Accountability gets incredibly fuzzy. Who do you hold responsible when an agency rule goes wrong? It's hidden in bureaucratic layers. Compare that to a vote in Congress. It's public, debatable, and representatives face the voters. You lose that transparency, that direct link.
And this also fundamentally changes how we think about our rights. He argues they become more like permissions.
That's perhaps the most chilling outcome for liberty. Think about administrative licensing. The FDA has to approve a drug before you can sell it. The FCC has to grant you a license to broadcast. What licensing does is it starts from a position of prohibition. You can't do this thing unless we give you permission. It flips the traditional American idea. Instead of being free to act unless a law specifically stops you, you're stopped from acting unless an agency specifically permits you.
That's a huge shift from life, liberty, and the pursuit of happiness being inherent rights.
It's a total inversion, and it gives the administrators, the licensors, enormous power. They can attach conditions to that permission, conditions maybe Congress never envisioned. It subtly transforms rights into privileges granted by the state. It replaces law with policy, consent with expertise, and rights with permissions. All in the name of making things run smoothly, conveniently.
So the administrative state, in this view, achieves convenience by bypassing constitutional forms, replacing consent with expertise.
That's a great summary of the liberty problem, yes. The founders built a system designed to make government power difficult to wield precisely to protect individual liberty, channeling it through specific, accountable institutions. Administrative law, he argues, finds ways around those channels, insulating power within expert bodies that are primarily loyal to the executive, not the people or the Constitution structure.
Which brings us to the courts. If this system is so constitutionally problematic, why haven't the courts stopped it? You mentioned deference earlier. That seems key.
Deference is the linchpin that allows this system to persist, in Hamburger's view. It's what makes administrative power superlegal above the law in a functional sense. When courts defer to an agency, they're essentially agreeing not to exercise their own full, independent judgment on the meaning of the law or the facts of the case.
Like James I saying his prerogative was no subject for the tongue of a lawyer.
Exactly the same kind of claim, just modernized. Judges like Koch pushed back against the king. But modern courts, particularly since the Chevron decision in the 1980s, often do defer. They yield to the agency's interpretation of statutes, especially if the law seems ambiguous. They effectively say, well, the agency has the expertise, so we'll go with their reading, even if we might read it differently.
Can you just quickly remind us what Chevron deference basically means in practice?
Sure. In simple terms, if Congress writes a law that's a bit unclear, maybe it tells the EPA to regulate something using appropriate methods, and the EPA then issues a rule defining what appropriate methods are, Chevron generally tells a reviewing court, stick with the EPA's definition as long as it's a reasonable interpretation of the statute. The court doesn't get to substitute its own preferred interpretation. It defers its judgment to the agency.
And how does the standard legal test for reviewing agency actions, the arbitrary and capricious standard from the Administrative Procedure Act, APA, play into that?
Well, that standard shifts the whole focus of the court's review. Instead of asking the fundamental constitutional question, was this rule made by the body authorized to make law, Congress? The judge ends up looking at the agency's decision-making process. Was it rational? Did they consider the right factors? Did they explain themselves properly? It becomes a review of the agency's thinking, its rationality, rather than the legality of its power source.
So the court asks, did the agency have good reasons? Instead of, did the agency have the constitutional authority?
That's the shift Hamburger points to. The courts end up examining the agency's paperwork and reasoning to sort of backfill the legitimacy that's missing because the rule didn't go through Article 1. Checking the agency's logic, he argues, is not the same as checking if the power itself is constitutionally valid.
And what are the real-world results of this deference, especially when it comes to those administrative adjudications we talked about?
Two big ones stand out. First is fact deference. When an agency finds someone violated a rule in its own hearing, Article 3 courts reviewing that decision usually have to accept the agency's findings of fact if they're supported by substantial evidence. They don't retry the facts. This means the agency effectively gets the final say on what happened, largely displacing the traditional role of a jury in finding facts. The agency is investigator, prosecutor, fact finder, and initial judge, all shielded from deep judicial second-guessing.
And the second consequence, you mentioned immunity for the officials.
Historically, if a government official acted illegally enforced an invalid rule, seized property unlawfully, you could often sue that individual officer for damages. It was a direct check on abuse. But over time, through doctrines like qualified immunity, it's become much harder to hold individual officers personally liable. They're largely shielded if they were enforcing agency rules or policies. This creates, Hamburger argues, a kind of privileged class of officials who aren't subject to the same legal accountability as ordinary citizens. And of course, protecting the officer reinforces the legitimacy of the administrative action itself.
Okay, this has been a deep dive indeed into why Philip Hamburger sees the entire administrative apparatus not as progress, but as a dangerous step backward, something fundamentally at odds with constitutional liberty.
A profound historical retrogression, yeah. That's his core thesis. He sees it as systematically bringing back the very forms of consolidated, extralegal, and unaccountable power that the whole structure of American constitutionalism was designed to prevent. It's the old temptation of absolute power, just dressed up in modern bureaucratic clothes, justified by efficiency.
So if we had to distill the most fundamental takeaway from this critique for you, the listener,
it's that liberty, in this view, depends absolutely on government binding us only through two channels: laws passed by our elected representatives in Congress, and judgments issued by independent courts with due process, including juries. When administrative agencies step outside those channels, substituting policy for law and convenience for constitutional process, that core liberty is eroded. The source of power shifts from the people's consent to administrative command.
Striking. Hamburger points out the old royal prerogative didn't always look tyrannical at first. It often started small, seemed reasonable, justified by necessity. Modern administrative power certainly makes similar claims. It's efficient. It's necessary for complex problems. If he's right that our constitutional system has increasingly given way to those claims, what's left, other than the law itself, to help us even recognize, let alone resist, what he calls this soft absolutism, this gradual replacement of self-government with rule by administrators.
Well, that's about all the time we have. You've been listening to the deep dive from Wake Up and Smell the Freedom, where ideas percolate. Thanks for joining us as we continue to explore the ideas that shaped liberty and continue to shape us today. Remember, the pursuit of liberty begins with understanding, and understanding begins with asking the right questions. Until next time.
Bye-bye.